requested, it is an exception to the requirement to produce. The counsel also acknowledged that there have been, over the last, I think since September 2008, if I can remember specifically, over 100 email requests of one kind or another related to public records requests alone. There are other documents that don't relate specifically to that. And as the court's aware, we were forced to go into justice court and get an injunction against harassment that prevented Mr. Videen from contacting the administrative employee, and we set up a special procedure for the water master, who normally spends his time in the field making sure the water is delivered to the residents, to become the public records officer and deal with Mr. Videen. All of these requests, except one, have come from Mr. Videen. Mr. Jones' only action in this was last spring to ask for legal bills. What they don't tell you is that I wrote back to him and told him I'd have to examine them and redact any information that would be privileged. And he again wrote back and said, no, I don't want you to do anything. Well, he was effectively asking the district to waive attorney-client privilege. It's not unusual to have legal bills discovered. Been in a number of cases where that's true, but redaction is always allowed, and either in discovery in a civil case or in a public records case. And so going specifically to where we are in this proceeding and reminding ourselves that the pleadings are not completed, because unless you dismiss our counterclaim, they will need to have an opportunity to reply specifically to it. As to their first request, they had previously asked for the email addresses of all 800 residents of the district, and we had denied that on privacy grounds under the Lake decision. They then came back with this request, which is a very large request for all these emails, obviously for the same purpose. And we raised the privacy defense under the Lake in our response to them. And that has put that item, in our view, at issue here, and not appropriately subject for this kind of initial relief under this proceeding.
Well, counsel, what is it that you think I should have some kind of evidentiary hearing before I decide whether the documents need to be produced, or what more do I need to do besides read the briefing and have an argument?
Well, we believe, Your Honor, that there are other facts that the pleadings have not brought out, and there are additional facts that have been brought into this case outside the pleadings that make it inappropriate for this kind of proceeding. There is a complaint, there is an answer, there is a counterclaim. We believe that the appropriate way to do this would be to have the court allow the reply to the counterclaim to be filed and set a procedural schedule that would allow a full expiation of facts that are relevant to this to come out.
Well, even assuming, counsel, that I just deny the motion to dismiss the counterclaim and we order a reply on the counterclaim, the question of whether an injunction ought to issue for harassment is different than the question of whether the documents need to be produced. So I struggle a little bit with what is it that I need to do in order to determine the initial question based on the special action or the lower